Hi everyone, I'm Eva Janta from KPA Lawyers. One of my areas of practice is criminal law, and today I'm going to talk to you about how pre-sentence custody works in Ontario. Pretrial or pre-sentence custody is a form of credit given to individuals who are detained in custody before their trial. It is intended to recognize the negative impact that being held in custody can have on an individual's mental and physical well-being, as well as their ability to prepare a defense. The amount of pre-sentence custody credit a person is eligible for is calculated based on the length of time they were held in custody before their trial, and is intended to be subtracted from their sentence if they are found guilty. This is also often called Summers credit, from the Regina v. Summers case, Supreme Court of Canada in 2014. The calculation of pre-sentence custody credit is based on a 1.5 to 1 ratio. This means that for every day a person spends in custody before their trial or plea, they will receive 1.5 days of pre-sentence custody credit. For example, if a person spends 100 days in custody before their trial, they would receive 150 days of pre-sentence custody credit. It's important to note that there are certain circumstances where pre-sentence custody credit may not be awarded or may be limited, such as if the individual was serving another sentence at the same time, or if they were released on bail and then later rearrested. In addition, there are circumstances where enhanced credit is given for particularly hard pre-sentence incarceration conditions. This is called Duncan credit, from the 2016 Ontario Court of Appeal case Regina v. Duncan. Duncan credit is not applied with a strict mathematical formula, and it does not increase the amount of pre-sentence custody. Duncan credit is a mitigating factor when the judge is deciding what an appropriate sentence should be. For example, a judge might consider the appropriate sentence for a particular crime to be 12 months in typical conditions. However, because of particularly harsh custody conditions, an offender might receive 8 months as the appropriate sentence. It's important to appreciate the difference between Summers and Duncan credit. Summers credit is a deduction from the appropriate sentence. It is always capped at 1.5 to 1, and it's used to give credit for typical conditions in pre-sentence custody. Duncan credit is not a deduction from an appropriate sentence. It is a mitigating factor that is taken into account when determining the appropriate sentence. It can be applied when pre-sentence custody occurs in particularly harsh conditions, such as excessive lockdowns, overcrowding, or time in solitary confinement. I hope this has been a helpful explanation of how pre-sentence custody works in Ontario. Thanks, and go to our website to book a consult if you have any further questions.